Margaret spent nearly $4,000 setting up a trust with an attorney almost 15 years ago, and for all those years, she slept soundly, believing her home, her savings, and her family's future were completely protected. She had the binder to prove it, a thick, official-looking document sitting on a shelf in her study, untouched for over a decade. When she passed away, her children expected a smooth, simple transition, exactly what a trust is supposed to provide. Instead, they discovered something Margaret never realized herself. Her house, the single largest asset she owned, was never actually transferred into the name of the trust. The trust existed on paper, beautifully written, perfectly signed, but her home still legally belonged to her personally, not to the trust she paid good money to create. That one missing step meant her house still had to go through probate court anyway, the very process the trust was supposed to help her family avoid entirely. Margaret didn't do anything careless. She simply trusted that creating the document was the finish line, when in reality, it was only the very beginning. Welcome back to Retire's Guide, the channel built for people who want to protect everything they've worked an entire lifetime to build. If you're new here, take 2 seconds right now and hit that subscribe button, because every single week we break down exactly these kinds of financial and legal blind spots, the quiet mistakes that sit untouched for years until the moment they suddenly matter most. Today we're talking about trust funds, and if you already have one, or you're even considering setting one up, what you're about to hear could completely change how you think about it. A trust isn't a magic shield that automatically protects everything the moment you sign it. It's a tool, and like any tool, it only works correctly if it's set up properly, maintained over time, and actually used the way it was designed to be used. Let's walk through exactly where trust funds quietly go wrong, and what you can do to make sure yours never becomes one of these stories. Let's start with the mistake that caught Margaret completely off guard, and it's one of the most common trust-related problems families face, something attorneys often call funding the trust, or rather, failing to fund it. Creating a trust document is genuinely just the first step. The second, equally important step is actually transferring your assets into the name of that trust, retitling your home, your bank accounts, your investment accounts, so that legally the trust itself owns them, rather than you owning them personally. This second step requires real, deliberate action. Deeds need to be changed and properly recorded. Account titles need to be updated directly with each financial institution. This part of the process is sometimes overlooked, either because people assume their attorney handled it automatically, or because new accounts opened years after the trust was created simply never got added to it. An unfunded trust, no matter how well written, doesn't actually control assets that were never legally placed inside of it. Those assets still pass through probate, exactly as if no trust existed at all, completely defeating one of the primary reasons most people create a trust in the first place. This leads directly into the second major mistake, which is forgetting to add newly acquired assets into the trust after it's already been created. Life doesn't stop moving once you sign your trust paperwork. You might sell one house and buy another. You might open a new investment account, refinance your mortgage, or inherit money from a parent. Each of these events can create a new asset that exists entirely outside of your trust, simply because nobody went back and specifically retitled it. Many people assume that once they've gone through the trouble of creating a trust, everything they own going forward is automatically included, but that's not how it works. Your trust only controls what's actually been placed inside it, and every new account or property purchased afterward needs to be deliberately added, almost like depositing something into a container that doesn't fill itself. Let's talk about another mistake that creates real confusion for families, and that's not fully understanding the difference between a revocable trust and an irrevocable trust. These two types of trusts serve very different purposes, and confusing them can lead to serious misunderstandings about what your trust actually does. A revocable trust, which is what most people set up for basic estate planning purposes, can be changed, amended, or completely undone at any point while you're still alive and mentally capable. This flexibility is helpful, but it also means a revocable trust generally doesn't offer the kind of asset protection some people assume it does. Because you can change it whenever you want, the law generally still considers those assets to be yours, meaning they can still be reached by creditors or counted for certain government benefit eligibility calculations. An irrevocable trust, on the other hand, generally cannot be changed once it's established, which sounds restrictive, but that same restriction is exactly what can provide stronger asset protection and certain tax advantages in specific situations. Many people create a revocable trust assuming it provides the same protection as an irrevocable one, only to discover, sometimes during a health crisis or a long-term care situation, that the flexibility they valued earlier actually limited the protection they needed later. Now let's talk about something that quietly affects an enormous number of families, And that's failing to update the trust itself after major life changes. Very similar to the mistakes we've discussed with wills and beneficiary designations in earlier videos, but specific to trust documents. A trust written years ago might still name a former spouse as a beneficiary or a trustee simply because nobody went back to update it after a divorce. It might leave out a grandchild who was born after the trust was created. It might still name a sibling as a successor trustee, even though that sibling has since passed away, moved across the country, or developed health issues of their own that make serving in that role unrealistic. A trust isn't a one-time document any more than a will is. It's meant to evolve right alongside your life, and skipping that ongoing maintenance can leave your trust reflecting a version of your family and your wishes that simply no longer exists. Let's talk specifically about choosing the wrong successor trustee, because this mistake creates significant problems down the road. Your successor trustee is the person who steps in to manage and eventually distribute the trust's assets once you're no longer able to do so yourself, whether due to incapacity or after you've passed away. Just like choosing an agent for a power of attorney, this role requires real organizational skill, financial responsibility, and a genuine willingness to take on what can be a demanding, sometimes lengthy responsibility. Naming someone simply because they're the oldest child, or because you don't want to hurt anyone's feelings by choosing someone else, can place enormous pressure on a person who isn't actually well suited for the role. Even worse, many people never have a direct conversation with the person they've named, meaning that individual may not even fully understand what's expected of them until they're suddenly thrust into the position during an emotional, difficult time. Here's a mistake that's becoming increasingly relevant as more families deal with retirement accounts alongside trusts, and that's naming a trust as the direct beneficiary of a retirement account without fully understanding the tax consequences involved. This can sometimes be done intentionally and correctly for specific planning purposes, particularly when a trust is carefully drafted to qualify under certain specific rules. But when it's done without proper guidance, naming a trust as a beneficiary on an account like an IRA or a 401k can sometimes accelerate how quickly that money must be withdrawn after your passing, potentially creating a larger, faster tax burden than your family would have faced if a person had been named directly instead. This is exactly the kind of detail that requires specific guidance from an attorney or financial advisor who understands both your trust and your retirement accounts together, rather than treating these two pieces of your financial life as if they exist completely separately from one another. Let's also talk about something that surprises a lot of people: the assumption that a trust automatically avoids estate taxes. For the vast majority of retirees, this concern doesn't actually apply, because estate tax generally only affects estates above a certain, fairly high threshold. But some people create a trust specifically believing it provides significant tax savings, without understanding that a basic revocable trust, the most common type most families use, generally doesn't reduce estate taxes at all on its own. It can still provide real, valuable benefits, like avoiding probate and maintaining privacy, but assuming it automatically reduces taxes when it actually doesn't can lead to confusion later, especially if other parts of an estate plan were built around that same incorrect assumption. Now let's talk about a mistake involving do-it-yourself trust documents, something that's become increasingly common as more people turn to online templates and software to save money on legal fees. There's nothing inherently wrong with wanting to save money, but estate planning documents, including trusts, often need to meet very specific state-by-state legal requirements to actually be valid and enforceable. A generic template downloaded online might not include language required in your particular state, might not be properly witnessed or notarized according to your state's rules, or might simply use outdated legal language that no longer reflects current law. Families sometimes discover these gaps only after someone has already passed away, at exactly the moment when fixing the problem is no longer an option. A modest investment working with a qualified estate planning attorney up front often prevents a far more expensive and stressful problem for your family later. Let's talk about something a little more personal, because trust-related conflict often isn't really about the legal document itself, it's about communication, or the lack of it. Imagine a father who sets up a trust specifically designed to distribute money to his 3 children gradually over several years, rather than all at once, perhaps because he's concerned about one of his children managing a large lump sum responsibly. This can be a genuinely thoughtful, protective decision, but if he never explains his reasoning to his children while he's still alive, that same decision can feel, after his passing, like a message of distrust or unequal treatment, even when his actual intention was protection rather than judgment. Having an honest, calm conversation about your reasoning while you're still able to have it can prevent years of hurt feelings and confusion that no amount of careful legal drafting can fully prevent on its own. Here's another situation worth understanding clearly. What happens when there's a conflict between what your trust says and what your will says? Many people create what's called a pour-over will alongside their trust, a will specifically designed to catch any assets that were accidentally left outside the trust and direct them into it after death. But if that pour-over will wasn't properly drafted, or if it conflicts in some way with the trust's own instructions, it can create exactly the kind of legal confusion and delay a trust was originally meant to prevent. Making sure your will and your trust were drafted together, reviewed together, and clearly coordinate with one another, rather than existing as two separate documents that were never actually checked against each other, is essential to making sure your full plan actually works as one cohesive whole. There's another mistake worth discussing, one that often surfaces only after a trustee has already been managing things for a while, and that's a lack of clear accountability built into how the trust operates. Some trusts include specific requirements for the trustee to provide regular accounting, clear documentation showing exactly how funds were spent, invested, or distributed. Others are written more loosely, simply trusting that whoever serves as trustee will naturally act responsibly without much oversight. While most trustees genuinely do act with good intentions, the absence of clear accountability requirements can create real problems if questions or disagreements ever arise among beneficiaries. A sibling managing a trust on behalf of brothers and sisters, for example, might make perfectly reasonable decisions, but without documentation showing the reasoning behind those decisions, other family members may begin to wonder, sometimes unfairly, whether something improper is happening. Building clear, regular reporting requirements into a trust from the very beginning isn't about assuming the worst of the person you've chosen. It's about protecting everyone involved, including the trustee themselves, from misunderstandings that can otherwise quietly grow into real family conflict. It's also worth addressing a situation that's becoming increasingly common among retirees who have remarried later in life, and that's how a trust handles a current spouse alongside children from an earlier marriage. Many couples in this situation set up what's sometimes called a joint trust, intending for the surviving spouse to be cared for first, with remaining assets eventually passing to children from a prior relationship afterward. This can work beautifully when it's drafted carefully and specifically for this exact purpose, but problems often arise when a standard, generic trust template is used instead, one that wasn't actually designed with a blended family structure in mind. Depending on the specific language used, a surviving spouse could end up with broader control over trust assets than originally intended, potentially limiting or even eliminating what eventually reaches children from an earlier marriage. Families in this situation almost always benefit from working with an attorney who specifically understands blended family planning, rather than relying on a generic trust structure that wasn't built with these particular dynamics in mind. It's worth touching on one more practical reality before we move toward wrapping up, and that's the ongoing cost and effort associated with maintaining a trust properly. Because some people are surprised to learn that creating the document is rarely a one-time expense. Depending on how your trust is structured, there may be periodic costs involved in updating it, retitling newly acquired assets, or working with a financial advisor to ensure investment accounts remain properly coordinated with the trust over time. This isn't meant to discourage anyone from using a trust, since for many families the benefits, avoiding probate, maintaining privacy, and providing clearer instructions, far outweigh these ongoing considerations. But understanding up front that a trust requires occasional attention and occasionally modest additional cost, rather than assuming it's something you pay for once and never think about again, helps set realistic expectations from the very beginning. So let's talk about what you can actually do, starting this week, to make sure your trust actually protects your family the way you intend. The first step is confirming whether your trust has actually been funded properly. Pull out your deed, your account statements, and compare the names listed on them directly against the name of your trust. If your home or your accounts still show your personal name rather than the trust's name, that's a clear sign something important may have been missed, and it's worth addressing directly with an attorney as soon as possible. The second step is reviewing your trust specifically for any major life changes that have happened since it was created. Marriages, divorces, births, deaths, changes in your relationship with your chosen successor trustee. Each of these is a clear signal that your trust may need updating, the same way a will or a beneficiary designation would. The third step is having an honest conversation with whoever you've named as your successor trustee, making sure they actually understand the responsibility, feel genuinely willing to take it on, and know exactly where to find the trust documents and relevant account information when the time eventually comes. The fourth step is making sure your trust and your will work together as one coordinated plan, rather than two separate documents that were created at different times without ever being reviewed alongside each other. If you're not certain whether they align, this is exactly the kind of question worth asking a qualified estate planning attorney directly. And the fifth step is committing to revisiting your trust on an ongoing basis, not just once after it's created, but every few years or anytime something significant changes in your life. Treating your trust as a living, evolving part of your financial life, rather than a document you sign once and never look at again, is ultimately what determines whether it actually works the way you intended when your family needs it most. It's also worth mentioning a pattern that has unfortunately become more common in recent years, sometimes referred to as trust mills, where seminars or aggressive sales presentations push generic trust packages on retirees, often bundled together with other financial products, without ever truly evaluating whether that specific structure actually fits an individual family's situation. These presentations can feel reassuring in the moment, professional, polished, and urgent, but a trust created this way is sometimes poorly suited to the actual assets and family circumstances involved, or worse, never gets properly funded at all once the excitement of the presentation fades and real life resumes. If you've ever attended a seminar like this and walked away with a trust package, it's worth having that document reviewed independently by an attorney who wasn't involved in selling it to you in the first place, simply to confirm it genuinely fits your specific situation rather than a generalized sales pitch. Finally, it's worth remembering that even a well-drafted, properly funded trust benefits from periodic professional review. Not because something is necessarily wrong, but because estate planning practices, financial products, and family circumstances all continue evolving over time. An attorney who specializes in this area can often spot small issues, an outdated reference, a missing successor trustee, an asset that slipped outside the trust, long before they ever become a real problem for your family. Treating this kind of review as routine maintenance, similar to a regular checkup, rather than something you only think about when a crisis arises, is often the simplest way to keep your trust working exactly the way you originally intended. Let me share one more story before we close, because it shows how this issue can affect even families who genuinely did everything they thought was right. Consider a man named Arthur, who created a trust with his wife many years ago, naming their 2 adult children as equal beneficiaries. Years later, after his wife passed away, Arthur remarried, and life moved forward in a new, happy direction. What Arthur never got around to doing was updating the trust to reflect his new marriage. When Arthur eventually passed away himself, his second wife discovered that the trust, still written exactly as it was decades earlier, made no provision for her whatsoever. Legally, everything passed exactly the way the original document specified, directly to his 2 children, leaving his current wife of many happy years with nothing from that particular trust. Nobody did anything wrong on purpose. Arthur simply assumed that because he had a trust at all, it would naturally reflect his current life, without realizing that assumption only holds true if someone actually goes back and updates it along the way. Stories like Arthur's and Margaret's remind us that a trust isn't something you simply check off a list once and forget about. It's an ongoing responsibility, one that requires attention not just at the moment it's created, but throughout every chapter of life that follows. Neither of these families experienced anything dramatic or unusual. They simply trusted that the paperwork itself would somehow keep pace with their lives automatically, without realizing that responsibility never actually transfers away from the person who created it in the first place. If something in this video gave you a moment of clarity today, scroll down right now and leave a comment letting me know whether your trust has been properly funded or whether this is the first time you're realizing that might be worth double-checking. I read every single comment, and so many of the most valuable conversations on this channel begin exactly there, with someone sharing their own experience or asking a question that ends up helping everyone else watching too. And if you know someone, a sibling, a close friend, a fellow retiree, who might need to hear exactly this today, please take a moment and share this video with them. A trust is one of those things most people assume is already fully protecting their family, right up until the moment they discover it isn't, and a simple share could help someone avoid exactly that moment before it's too late to fix. Before you go, make sure you're subscribed to Retire's Guide, because there's another important piece of this conversation we haven't covered yet, one involving how long-term care costs can sometimes interact with trusts in ways most families never expect, occasionally limiting access to certain benefits depending on how and when a trust was structured. We'll be walking through exactly how that works very soon, and it's something every single person watching today is going to want to understand clearly before it potentially affects their own family. Stay close, stay informed, and thank you so much for spending this time with us today. We'll see you in the next one.